We are absolutely thrilled that the 11th Circuit Court of Appeals has come to its senses and vacated the ruling that they made in July in favor of the City of Orlando. They've thrown it out, withdrawn it. We are back to the point where the judge in Orlando ruled that the ordinance is unconstitutional. What we got is a hearing by the full court, and this is really, really rare. Even I didn't know how rare it was until I looked it up yesterday. Over the last 10 years, the average is 27,000 cases a year are decided by federal appeals courts. 75 get a rehearing by the full court. So, we are really, really thrilled that we got their attention. We had to have 7 judges vote in favor of rehearing the case. And I'd like to think that they wouldn't vote in favor of rehearing it unless they at least had some idea that they would be going the other way. So at this point, I'm back to being kind of optimistic about the way it'll all turn out. What I got yesterday was a 1-page order saying we're throwing out the ruling in favor of the city. You're going to get heard by the whole court, and we'll send you some more stuff pretty soon. And they will send an explanation of exactly what they want to hear, whether they want additional briefs, whether we're going to get to go up to Atlanta and argue in person again. I just don't know the answers to that stuff yet. And we're sort of assuming that it's the political speech part of the case, because that's what Justice Barquette dissented about and wrote about specifically. And I think even the folks who are on the freedom of religion side of our case at this point would admit that the political speech argument has gotten stronger. And that's because what the 11th Circuit did in July contradicts a lot of prior rulings by that court and also by the Supreme Court. Sure, but this is a rehearing in front of the full court. En banc is the way lawyers talk about it. And the next step is the United States Supreme Court. Equally slim odds of getting heard, although with a strong dissent written by Justice Rosemary Barquette, who was a nun before she went to law school. Interesting career track. And a rehearing by the full court. We've just increased our chances of actually getting to the Supreme Court if that's where we need to go. Okay. The issue is whether sharing food with hungry and homeless people in public spaces, like is going on right behind me right now, is expressive conduct protected by the First Amendment. And for years and years, the courts have recognized that you have to look at the context and the circumstances. Back to the you can't yell fire in a crowded theater. You can't falsely yell fire in a crowded theater. Obviously, if the theater's burning, you can yell fire. So we have to know the context. If I see you burning a flag, how do I know if you're protesting or you're trying to keep yourself warm on a cold night? I have to know the circumstances. We talked to the court about their cross-burning cases, and this court's in Atlanta, Georgia. If I burn a cross in your yard, it's a threat. Get out of town, whatever, but it's a threat. If we burn a cross in a field out in the middle of nowhere at a Klan meeting, now it's a symbol of unity. You have to know the circumstances. And what the court did in July was they stripped away all the circumstances. They said you can't look at where this is or buttons or T-shirts or anything that goes along with it. All we can look at is handing a plate of food to another person.